Often when looking at powers of appointment, they're classified in two ways, general or limited or special. Those two different classifications have significance for tax and asset protection purposes. However, there's an often ignored but another useful classification, and that's exclusionary versus non-exclusionary. Most powers of appointment are exclusionary in that the power holder could exercise that power to exclude members of a closed class of appointees. But within a non-exclusionary power, you can't exclude anybody within a certain class of appointees. Now, while this could be helpful for drafting, especially in a mixed marriage scenario, it's important to note that the use of this type of non-exclusionary power of appointment could create an unanticipated claim against a trust for excluded class members, which may include creditors of the estate of the power holder. I'm Griffin Bridgers, and this is 10 Minutes with Griffin. For today's episode 189, we're just going to look at exclusionary powers of appointment and their corollary, non-exclusionary powers of appointment, what they mean, and how they're deployed. As always, this presentation is not intended to substitute for legal or tax advice. It is provided for educational purposes only. And if you'd like a copy of these slides, please email me at griffin.bridgers@gmail.com. Now on to the presentation. Now, in a previous episode, I've discussed the two tax and asset protection classifications of powers of appointment. That's a general power of appointment and a non-general power of appointment, which could also be called a special or limited power of appointment. Now those have significance, like I said, from a tax and asset protection purpose standpoint, and we could even further break those down into lifetime versus testamentary powers of appointment, but that's a discussion for another time. What we're focused on today is another classification which often flies under the radar, and that's exclusionary or non-exclusionary powers of appointment. So today's episode is about the difference between the two. Now, before we really get into that difference, in order to understand the difference, you need to look at the classes of appointees within a power of appointment. Now, appointees are the persons who can benefit from the power of appointment. Instead of naming a bunch of individuals, often what would happen is that the power of appointment would be exercised in favor of a certain class. That could include, for example, descendants of the power holder or even descendants of the creator of the power. It could include charities. It could include individuals and entities. Now, it's important to note that within those classes, they could be closed or open. So typically, we're going to be looking for a closed class, which would be something like descendants of the power holder. Now, that's closed at the time of exercise. It may not be considered closed at the time of the creation of the power of appointment, but it's important that we consider whether the class is closed, because that's going to be the key to creating a non-exclusionary power of appointment if we want. Because why classes matter is that powers of appointment are not fiduciary powers. So the power holder really has the ability to exercise that power in any way they want. They could pick and choose within the class of appointees as to who might benefit, as long as they respect the method of exercise and don't appoint outside of the named class or classes. So, within a class of appointees, since the power holder can pick and choose who receives how much, they also have the choice to exclude persons from that class when that power of appointment is exercised. So because of that exclusion of persons within a class, that's what's known as an exclusionary power of appointment. Now this describes most powers of appointment. They're going to be exclusionary in that you can exclude members within a class or provide disproportionate amounts within that class as well. But importantly, once again, for this to work, we can have any sort of class we want, be it open or closed. With non-exclusionary powers of appointment, that's simply the corollary. And what that says is that if you have a closed class, you can't omit any appointee within that class. So, for example, we could have a situation where the power holder could exercise in favor of their descendants, but if this was non-exclusionary, it would mean that at least each member of the first generation and possibly representatives of a deceased member of the first generation, either per stirpes or per capita, would have to benefit from that power of appointment in some way. So in other words, the power holder with a non-exclusionary power of appointment couldn't omit a family line within that classification of descendants. Now, it's important to note too that the non-exclusionary limitation could be within the class or across classes. So I talked about closed classes earlier. So you could have this where you can say that you can't omit any recipient within a certain class. So for example, if we had individuals and entities or charities, those are open classes, and it would be impossible to create a non-exclusionary power of appointment within that broad class because the choices could be infinite. But you could require across classes for at least some benefit to go to an open class. Now, within a class itself, to have a non-exclusionary power of appointment, the class must be closed, because if you have infinite choices, there's no way to make it non-exclusionary, because you'd have to look at every single charity within the world if you had, for example, a non-exclusionary power to charitable organizations. But descendants makes sense here if you wanted it to be non-exclusionary. Now, it's important to note that when the power is drafted and created, descendants might not technically be a closed class at the time, because it could be expanded by birth or adoption that happens after the power is created and after the creator of the power is deceased. But importantly, when we test whether the class is closed is upon the exercise of the power of appointment. And when it's exercised, we know who is included in that class. So at that point, it would be okay to have a non-exclusionary power within that closed class. Or if you have an open class, you'd have to have multiple classes that may or may not be capable of closure, but you'd have to maybe specify that you can't omit the entire open class within the power of appointment for it to be non-exclusionary. Now, where might we use this? Well, as I mentioned earlier, the common example would be a mixed marriage scenario. Now, in most cases, the conservative drafting strategy in a mixed marriage is not to give spouses a power of appointment, because they can use that to disinherit their step family. It takes the control of the first spouse to die over their estate plan out of their hands and puts it into the hands of the surviving spouse, who might want to benefit their own blood relatives against their step family, in essence, from the marriage to the deceased spouse. Now, if you need to create a power of appointment, maybe for tax planning purposes, what we could do here is use non-exclusionary powers of appointment. So, for example, within that power of appointment, we could say that the surviving spouse must exercise it possibly equally in favor of all of the donor's children or their representatives and all of the power holder's children or their representatives, which might give the spouse still some discretion to exercise the power to distribute outright or in further trust. But in other words, it can't change the economic benefit that each of those children's family lines end up with due to the exercise of the power of appointment. Now, this can be a double-edged sword, because while powers of appointment are not fiduciary and typically don't create a cause of action through exercise or non-exercise, a non-exclusionary power of appointment could give any excluded or omitted appointees a cause of action against the trust. That could extend to the trustee, maybe even the power holder's estate, or even other beneficiaries of the trust or appointees from that trust. Now, it's also important to note too that for tax planning purposes, you might include creditors of the power holder's estate as beneficiaries. And if they're included under a non-exclusionary power of appointment, that could be a bad outcome because it might give those creditors a cause of action against the trust as well. Now, typically, testamentary powers of appointment that you could exercise in favor of creditors wouldn't create any sort of cause of action or expose trust assets to those creditors because the power is exclusionary and it's really the power holder's choice as to whether or not those creditors benefit. Now that depends on state law a lot, but with a non-exclusionary power of appointment, obviously that gives those creditors more ammunition to make a claim against the pool of assets that power of appointment could have been applied to. Now, it's important to note too that the power may override the spendthrift clause within the trust simply by naming creditors as appointees. So if you're a trustee and you're looking to say, hey, creditors of a beneficiary can't make a claim against the trust under the spendthrift clause, well, guess what? With that power of appointment that names creditors of the beneficiary or their beneficiary's estate, you're probably overriding that spendthrift clause. So, non-exclusionary powers of appointment could help in some circumstances, but they can also create unanticipated problems in other circumstances. Now, as always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. But thank you for listening to this episode of 10 Minutes with Griffin, and I look forward to seeing you in the next one.